Today we're going to be talking about legal issues. Now, why are we talking about legal issues? Because these are the things that pretty much scare most counselors the most and get you all worried about, well, am I doing everything right? Am I dotting every I and crossing every T? Have I got myself covered? Or am I going to end up before the Behavior Sciences Board and all of these kind of things? So probably from an anxiety level, this is a very huge area. And we want to talk about that, and hopefully, although I'm going to give you a lot of information, at the end you're going to sort of realize that that's just part of the game that we're playing, and that you have to cover this, but that God is still in charge, and that He can take care of you. Let me just say to start with, I've been counseling here since 1991. And by the mercy of God, we have still not been sued. I have still not had any complaints before the Behavior Sciences Board or any of those kind of things. But first, to start out with, I want to make some legal things very clear to you about what you can and cannot do legally in this state and probably in most of the states in America. And we've covered this before, but I'm going to pull it all together. First thing, as a support group leader, do you have to have any qualifications? Do you have to do anything? And as long as you call yourself a self-help group, so you are suggesting what? I am just one of the people in the group that I am helping, and don't claim to have any expertise or anything specially in that group, then you're probably pretty safe. And most support group leaders don't have liability insurance or any of those kind of things because you're not claiming to be anything special. Now, if that's a therapy group, now you're claiming something special and you need to meet some of the other qualifications. How about of a lay counselor in a church? Well, the rules are that you have to be either an ordained pastor, a licensed minister, or be doing your counseling as part of a church, an official program of the church. And of course, I'm going to recommend to you have something in writing saying that your program is an official sponsored program of this church if it's not at the church. If it's already at the church, then I think most people are going to assume that you're an official program of a church. And there is one thing in this state under the professional counselor law that even allows that for nonprofit organizations, that they don't have to be licensed by the state to counsel within those organizations. So if you meet those criteria, you're pretty good. But a state licensed counselor, what do you have to do? You have to meet what all the requirements are. You have to be licensed by the board. You have to carry out what all the requirements are for that particular license. And many times, as we saw under supervision last time, how many hours did they have to have as a marriage and family therapist? 4,000 hours of experience and 1,500 hours of face-to-face supervised counseling. So we have all of these requirements. And then you have to have CEUs. Those are continuing education units, but many times they say you have to have so many units of DSM-4, you have to have so many, in a unit is 1 hour, or so many units of confidentiality. Under drugs and alcohol, you have to have so many credits for high-risk issues like HIV and things like that. So there are a lot of requirements, and you have to meet all of those. Of course, you have to pay so much every 2 years to keep your license up. And you have to meet all these unprofessional conduct requirements and those kind of things. And implied in that is probably the ethical codes of your profession. So basically, you either go the state direction or you go the Christian counseling direction. And of course, you can mix them. But the problem is going to be that if you mix them, they're probably going to hold you to the state requirements for everything. How about getting on the court list? Now, why would you want to get on the court list? We've talked about before that this is a very good means of getting clients. As an example, if you are a licensed drug alcohol outpatient clinic and you're on the list, and that list is given to people who have DUIs and they have to get this help, so they're going to try and find probably the cheapest person on the list or the cheapest organization on the list, or if you're the only Christian one or one of the few Christian ones, they might come to you for that reason. But there are other lists you can get on. Besides drug alcohol, another one is domestic violence. If you do an anger management domestic violence program, you can meet with the courts and get on their approved list if they accept what you're actually doing there. The problem is that whole area is changing. And anytime you get on these lists and these requirements, realize that the state laws might be changing. You've got to keep up with what's going on and jump through all the hoops and do all the right stuff to get on the correct lists. Another one in this state is gambling. That you have to do certain things and go through a certain amount of training to get on the gambling list. There's also another one that's called Senate Bill 123, which is a drug alcohol one that's a special type of a program, and you have to meet those requirements. Another one is mediation. You have to get so much mediation experience to get on the mediator list for the courts. Another is sexual offender programs. You have to have special training and convince them that you can handle that particular thing. Another one is parenting. Those are just the ones in this area, in this particular state, that you can get on lists for that will bring you in clients. And sometimes that's going to be your main source of clients for this particular specialty area. But probably one of the most interesting areas is testifying in court. Now let's first go through a few of the ropes here to understand something. If you get a subpoena, does that mean that you just automatically send your records to the person who has sent that to you? No, because that is usually one of the lawyers that has subpoenaed you, and they're on one side or the other side of this, and unless they send you a release of information from all the people involved that were in that session, don't do that. You just violated confidentiality. What you have to do is go back to them and say, I need a release of information, or I need a court order. If you have a court order, then you can release the information, but you need to put that in your records to make sure you don't send information. However, if they do give you a subpoena, you need to call them and see if you can get out of it some way. Step one is try to see if you can just write up a letter and send it to the courts. Now, why is that good? Because if they can get that put into that trial, they can't challenge you. All they have is a letter, this counselor said this and this and this, and it can't really be challenged. And of course, the second reason is you don't have to go. But if you can't get that, then you want to talk to that lawyer and say, well, this is the information I have. Is this what you really need? How about putting me on call? On call simply means if they really need you. Now, why do you want to do all that? Because the odds are fairly good when you show up, they're just going to continue the case anyway, and you're going to spend a lot of your time sitting there just waiting for things that they might not get around to. Now, some lawyers are very good and some judges are very good on that, and you can tell them, I'm sorry, I've got this many clients. I really can't cancel those clients. Can you schedule it in the morning? Can you schedule some better time? And usually they're going to work with you unless you have very germane information to that particular case. You're probably not going to be worth bringing in. But sometimes to form the case they have to, and you will have no choice to be able to go and no choice to have to cancel some of your clients and to work around the whole court situation. That's just the way it sort of is. Now, why are we trying to avoid the courts? Because it's a very adversarial relationship and actually can hurt your situation with your clients. What if you testify in court on something and some of the information you bring up is used against your client? But most of the time you'll be going supporting that client, but in some cases you're not. Some cases you know this person should not have their kids. You may be the one that reported them. And how's that going to help your overall situation? But if nothing else, if they're taking sides now of that client against that mate, what chances do you think you have of ever counseling them in marriage and family? So it polarizes things. Do you see what I'm saying? Now, another thing that you need to do, and in your case it doesn't apply unless you're here and you have a state license. But if you have a state license in this state, you have privileged communication. Now, what does that mean? It means before you testify, you have to say to the judge, Judge, I just want to let you know that I'm a state licensed counselor, and according to the law, I have privileged communication. Do you want me to continue to testify? If the judge orders you to testify, he has made a decision and you do that. Now, in a lot of cases like custody cases and abuse cases with kids, that overrides the privileged communication. But like in one particular case, it was a marriage situation. And so the judge then said to the attorney for the opposite side, will you allow him to testify? And they talked about it. How are they going to look if they don't let me testify? So they let me testify. They should have never done that. Because my testimony is what really turned the case around. And they should have said, no, he's not allowed to testify. We haven't given him permission to testify. And then I couldn't have said anything. But you have to clear that, do you see what I'm saying? So you are not legally doing something that you can be held to, especially since all court records are recorded down to your last word. So could they use that against you? Could the other person in the case maybe be tempted to use that against you? Beyond time, expect delays and continuances. Do not agree to be an expert witness. If you're not an expert witness, and none of us really qualify to be expert witnesses, what's the difference? In the one case, you're just testifying of what you were told and what you know. That's pretty simple. But an expert witness means you are an expert, say, on child abuse, and you are going to tell the court the ramifications of this case and what it's going to do to this kid, and so on and so forth. And do you think the other lawyer might challenge you? In all cases, expect they're going to try to make you look like an absolute idiot. Because if any of your testimony works against them, it's their job to discount you and your knowledge and try to make you look like an absolute idiot. I'll give you another situation. I was in this particular case. There were actually 4 lawyers involved for 4 different people. It was an abuse case. And one of the lawyers gets up and says, so you're a Christian counselor, are you? Well, what do you think about homosexuality? This case had nothing to do with homosexuality whatsoever. How can you make a judgment from DSM-4 if you believe that homosexuality is a sin and DSM-4 says it is not a mental disorder? How can we trust you to make a judgment concerning DSM-4? Do you see what he was doing? But did that have anything to do with the case? He was going to just discount me because I was a Christian. And you don't know. In that same case, I was testifying that I had seen the interview of this little child, and it looked to me that this interviewer was leading the child. They would ask the child several times, child would say no, 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 and they would finally get the child to say yes. But that was totally, completely discounted because the court had already reached the decision that this was child abuse. So because I didn't know the rules, of course the lawyers should have known the rules, and don't think the lawyers are going to protect you and that the lawyers are going to help you. This is not like on TV. I'll give you another situation. This was a situation in which I turned in a person as a pedophile. And the person was being tried, and they already had a previous conviction as a pedophile. And all the prosecuting attorney says, all I need you to do is go up to the stand and say that you're the one who turned this in. You got knowledge from one of your clients about this. Well, what do you think happened? It was nothing about that at all. When I got up there and I made a mistake, and I warn you, always be prepared, get all of your notes, memorize them all, because they're not going to let you look at your notes. Or if you're looking at the notes, you have to say, I'm now looking at my notes to check this out. So you need to memorize all the dates, you need to memorize all the information about everything that went on, and your testimony is probably going to be a year after it happened. So how much do you really remember? And I actually had a lot more information I could have said. And so the other side asked for an adjournment, and they want to talk to me and look at the records. Now, is that valid? And the district attorney doesn't even come with me to try to protect me from what they are trying to do. What are they trying to do? Affect the witness outside of the courtroom. What they found out, though, is when we looked at the records, that all the information I had was going to be absolutely damning to their client. And by the way, I had a couple dates turned around that they could use to discount me. So when they got back to the court, they said, we don't need to call this witness anymore, thank you. The good news was the person got convicted and got 14 years. But they didn't need my testimony. But I'm just saying, don't think that that other attorney is necessarily going to protect you and going to do all the nice things that I object or any of those kind of things. They may just let the other attorneys just wrap you around their finger and stomp on you. Preparation. Before you go in there, sit down with the party that's asking you to testify and find out what they want. Because here's another big catch in testifying. You can't just say what you want to say. You can't just give your opinion. The other lawyer, your lawyer, has to ask you the right questions to draw out the information. You can't just say, Judge, can I just tell you what I think about this case? No. It has to be all drawn out in a question and answer format, and if they don't have the right questions and they don't know what details or what information you actually have, that can help them. And then what if they don't have a good attorney? You don't know. You may not be able to testify anything. You might have all the information that could turn this entire case around, but because you're not asked the questions, you cannot bring out the information. Consider what's expected of you. Consider the documents you will need. Continue conferring as the case goes on so you know where it's at and exactly what they're expecting of you. But just because they tell you that and you get on the stand, don't think they might take it a totally different direction. Anticipate the anticipation, meaning that you're going to have some anxiety here. Be organized. Maintain your composure. But expect a conflicted relationship. Expect they're going to challenge your credentials. What do you think one of the first things that I will do when they ask me my credentials? I will give them my state credentials, and then I will say, and I have another degree, a PhD in Christian counseling that is not accepted by the state. Because that's the next thing they're going to ask. Where did you get your PhD from? What kind of a school was it? And so on. They're going to use that. So basically, I will just go and tell them that in the beginning, that I'm here as a master's level, state licensed clinical marriage and family therapist and clinical drug and alcohol counselor. But I'll bring the other one up just so they can't use it. I'm going to anticipate what's going on there. Expect to be challenged. You don't know the system. You don't know what angle they're taking. You don't know what game they're going to play here. Expect them to try and make a fool out of you. What's one of the things you need to be able to say? I'm sorry, I don't have the answer to that. See, another thing they'll try and lead to in another court case. I'm testifying and I've only counseled the child and the one set of parents. So what do you think the lawyer says? What do you think about the capability of the other set of parents to parent this child? See, what do I need to say? I'm sorry, Judge, I've never counseled them, I don't know them, so therefore I cannot make any judgment whatsoever concerning the ability of this other couple. But had I said something, what would they do? Maybe you look like a fool. Where do you get your information from? Are you not biased in this particular case? Testify only about what you really know. If you can't concretely back this up with facts, you say, if you're asking my opinion, this is my opinion. No, I don't have any concrete facts to back it up, because that's what they're looking for, is the concrete facts. Admit what you don't know. Expect the unexpected. Your job is to give valid testimony, not win the case. Another particular case. Here was the situation. And this is the one of the dad had been accused by the grandmother of possibly abusing this very young child. And they had done interviews and everything. I had seen one of the set of interviews, and it looked to me like they were just leading this child. But the case seemed like it should be a slam dunk case, because the dad who was accused of this abuse first had not been charged. The charges had been dropped. And second, he had died. So now what do you think the chances are of actual continued child abuse, which is the reason that SRS had the child in foster care? What do you think about that? So do you think that that's the way the case came out? No. They wouldn't release the child. Because, of course, their idea was, well, the mom didn't protect this kid. Of course, we had really no evidence that the kid had ever been abused. But SRS doesn't have to do what the courts do. And so the judge felt that it was more protective to keep the child in protective custody. And then you can try to work. I tried to work with the other counselors involved. No. What I finally had to tell the person is, I think what I need to do is I'm going to refer you to the counselors at that organization that is holding the protective custody, and you're going to have to sell yourself to those other counselors so they make a recommendation to the court, because you're not going to beat this one. But see, you learn. The good thing about these court things is you learn the flavor of what's really going on. But sometimes the best thing is to just say, uncle, and let them work with the courts and let them work through that system. Because I was not part of their organization. Of course, they didn't trust me. And they weren't going to work with me. So it was better for that client to go to that organization, get their own counselor there who could talk to the other counselors there, and she eventually got her child back that way. So just because it makes logical sense, don't jump to the conclusion that that's the way the court case is going to turn out. Another one of our counselors had a case, and she went there and she said, this person is dangerous, this person should not have any custody or ever see this child, and so on and so forth. And the court gave him visitation rights, and he tried to kill all the children, burn down their trailer house. It was his girlfriend that saved the kids. But the courts were totally wrong, and they wouldn't listen. So I'm just saying, this is a very interesting area, and to the degree you can stay out of it. But if you need to help, you need to help and do the best you can, right? Put it all in the hands of God. Don't expect the system to work out like you think the system should work out logically, because you can't really influence it. You can just give your testimony. That's all you can do, and learn from your experience. Next topic is association membership. Now, why am I talking about that under legal? Because it does have an effect on your cases in the future. Because if you are a member of an organization, although organizations do not require you to sign off on their ethical codes, what is the assumption? That you agree with their ethical code if you're a member of that particular organization. Because of that, I've dropped my membership. and the American Association of Marriage and Family Therapy. And I only hold a membership in the American Association of Christian Counselors. And we'll see later as we talk more about the situation with the homosexuals of what the situation is and why that's important that you watch what you do. If you're a member, you may be expected to live by that code, or at least could you believe a lawyer might bring that up and say, okay, you're saying you think that dual relationships in the church are okay, and you have a dual relationship here. How is that not malpractice? Here is the code, and this is what it says ethically. So are you not in ethical violation of this code? Here is the homosexual trap. This is what the homosexual lobby or the gay lobby is trying to do within the different counseling organizations. And this is particularly the American Counseling Association, American Association of Marriage and Family Therapy, the American Psychological Association. And this is what they're basically doing. They write something in their code, and this is what it says. It is malpractice to treat something that is not a problem or for which you are not trained. Well, is homosexuality in DSM-4? Since it is not, therefore, from their point of view, this is not a mental health problem, right? Secondly, they make the statement, there is no approved training for dealing with homosexuality. Third, there is no approved method for training with homosexuality. Now, that isn't true, but the ones they accept, it is true. So therefore, what are they saying? If you try to treat somebody in the area of homosexuality, you are committing malpractice because you don't have official training in the area and you don't have an approved scientific method for dealing with the area. So do you see what they're trying to set up? And they've actually used it. They had 2 cases where they sent in people asking for help that were plants from the gay lobby. And the person used an advanced informed consent that I'm going to talk about here in a little bit from AACC. And so they couldn't get them, but they did file a suit. And usually they're filing the suit to get your license taken away. And they're making progress because this guy didn't know enough about this and he was in advanced informed consent. But the client got saved. So therefore dropped the lawsuit. But don't think that could not happen to you. Do you see what I'm saying? It can be a setup. So what is this AACC advanced informed consent? They had one of their lawyers, who happens to be a counselor, go through and seek this all out and figure out how can we handle this so that you are not liable if you do it in a right and an effective way. The first thing they say, and this thing is about 8 pages thick, and the way you use it, and we have it available, is that you, before you do any counseling with this person, you say, I just want to let you know that this is a conflicted area. People have different opinions on the subject. And I want to let you know about that, and then you can choose if you want me to help you or not. And you get them to sign. And this is what it includes. The first thing it says is they respect the authority of DSM-4, and they're not treating a mental disorder because it's not in DSM-4. What they're treating is the anxiety and distress caused by a person that has different spiritual values versus what they are doing. It's the right of the client to determine his own morality and request treatment if he wishes. The intervention is not therapy, but a combination of counseling and spiritual formation. The diagnosis under DSM-4 is 302.93, sexual disorder not otherwise specified, or 309.9, adjustment disorder not otherwise specified, with a V code of religious or spiritual problem. So now we just got it back into DSM-4 because otherwise you couldn't charge insurance, right? The goal is to learn to live consistently with their religious beliefs. Part of the informed consent suggests that in this particular case, about 1/3 completely recover, about another third learn to live a celibate life but don't have feelings for the opposite sex, and another third possibly drop out of treatment. However, in Christian treatment, the success rate of reaching their goals is around 67%, which again would be a challenge, but you're telling the person this is what the research says, and it's all backed up by research. And that recovery is going to take between 1 and 4 years to work through these particular issues. Another thing it says that if required or if requested, that you will give them a referral to a gay affirming therapist. And you are not a gay affirming therapist. And that both agree not to sue, but to discuss any problems with a counselor, a mediator, and arbitration. And they sign all of this to cover all of your bases before you do any counseling in this particular area. My experience has been that people will sign this, especially if they're Christians and they're looking to try and get help. But it covers you. How about other malpractice suits? What do you think the most usual malpractice suits are? The first one is sexual impropriety. That the person somehow got involved in a relationship during counseling or within a period after the counseling. The state law you were going to see here requires 2 years before you can date somebody that you counseled. Some ethical codes say you never can. But the idea is somebody violates that. Same thing sort of with lawyers. Another huge one is homicide or suicide. Failing to warn or failing to prevent suicide. Another one is confidentiality. Somehow you let their information get out to somebody that shouldn't have. Dual relationships. There was a particular case of somebody that I knew because I had them actually, somebody I was counseling them, that was a licensed marriage and family therapist. And this therapist got so involved in a case, she was personally helping her client get out of a relationship with her husband. Well, how do you think the husband took that? A dual relationship and malpractice, and filed with the Behavioral Sciences Board against her. In another particular case, the person got in a money situation with the client and got filed with the board on that. So you have to watch out what you do there. Now, what's the problem with these malpractice suits? The biggest problem is, what's the insurance company, your liability insurance company, want to do? Resolve it out of court for the least amount of money that they can resolve it for. And where does that leave you when they agree to resolve the case? See, even if you have a perfect case against it, and there's a small probability they could lose, and lose millions, they might settle out of court for $500,000 or $50,000 or something like that, and the person might take it, but guess how you look? Guilty. And now everything you do from then on, you have to, for any liability insurance you get, for any of the boards, for any of the other organizations and everything that you do, I always ask the question, do you have any situations that somebody has filed something against you on the board or anything else? And just so you know, your liability insurance has a limitation on it for how much they will do for you if you get charged with sexual impropriety. It limits how much they have to pay, and it's not very much. If you don't cover your church as an other insured, what are they going to do? They're going to sue the deep pockets. They're going to sue your church if you're not covering it as an other insured. Other insured means your company has to take care of the lawsuit against the church also. If you're not under a corporation, what could happen? They can hold you personally liable for anything that goes above the limit of your liability insurance. You could lose everything you have. The effect on licensure boards, insurance panels. Another thing when you're trying to get in the insurance panels, what is it I always ask you? Do you have any lawsuits against you? Do you have any liability? Have you ever been accused? Have you ever paid anything? And they're probably not going to let you on the insurance panels if that's the case. Insurance renewal, same kind of thing. Even an accusation has to be reported to the Behavior Sciences Board. And liability insurance companies want you to call them if you even think there is a chance that you're going to be sued before you're sued. Now, what do? Well, if you have any of those cases come up, make sure you bring it up in supervision. Make sure you contact a number of other people. You contact the insurance company, and you document everything and other people's advice and so on and so forth. In other words, you have to cover yourself very strongly in this particular area. I say consult, consult, and consult is what you need to do. Document. Everything you were told, the advice you got, who you got it from exactly, when you got that information, why you did what you did, what the client did. In other words, your paperwork volume needs to increase a lot so you have some evidence, because you probably heard the saying, if it's not documented, you didn't do it. Do you see all of that? The last thing I want to do is I want to go over the unprofessional conduct regulations, and I'm going to do marriage and family therapy again. And I'm just going to almost read these to you and the main points. I don't expect you to get all of them, but if you see some interesting stuff in here that maybe you didn't think about, because this is going to give us sort of an overview of all the ways they can get you. Okay? This is unprofessional conduct. The law is 102-5-12. Engaging in fraud, bribery, deceit, misrepresentation, or concealing of material facts. Failing to notify the board within a reasonable amount of time that the licensee or an applicant or any other person regulated by the board, did you hear that? Has had a professional license, certificate, permit, registration, certification, or professional membership granted by any jurisdiction, professional association, or professional organization has been limited, conditional, qualified, restricted, suspended, revoked, refused, or voluntarily surrendered, or allowed to expire in lieu of an investigation. So basically, if you know anything about anybody else that's regulated by the board, or any problems that they have, or if you don't turn yourself in for all of these things, that's unprofessional conduct. You can lose your license over it. So you have to report even the other counselors around you and people around you if you know anything. Or has been subject to any disciplinary action. Notice that was even membership in organizations or anything else. Or professional association or professional organization has been demoted, terminated, suspended, reassigned, or asked to resign from employment. Has to be reported. Or has resigned from employment for some form of malfeasance, or has been convicted of a crime. Allowing another person to use one's license, interpersonating another person, conviction of the crime of resulting from or relating to one's professional practice. Furthermore, the licensee and registration application, if you basically sign anybody's application recommending them, but you believe them to be unqualified with respect to character, education, or relevant eligibility requirements. Aiding or abetting someone who's not credentialed. Failing to recognize or seek intervention in any personal problems of any of these people. Psychological distress, mental health difficulties that would interfere and negatively impact the professional judgment, professional performance of the person. refusing to cooperate in a timely manner in requests from the board, performing services inconsistent or incommensurate with one's training, education, or experience. See, there's the homosexual thing, isn't it? If you can't prove that you have any training. Treating any client, student, or supervisee in a cruel manner. Discriminating against any client, student, or supervisee. Failing to advise or explain to each client the respective rights, responsibilities, and duties involved in a marriage and family therapy. Failing to provide each client with a description of what the client can expect in the way of services, consultations, reports, fees, billing, therapeutic regime, and schedule, or failing to reasonably comply with that description. Description of the possible effect of proposed treatment when the treatment may be experiential. Informing each client, student, and supervisee of the financial interest that might be accrued. Failing to perform each client, student, or supervisee of the limits of client confidentiality. Failing to protect confidences, secrets, or information obtained in the client's records, except for the normal reasons. Disclosure of information presents a clear endanger the health or safety of the individual. Failing to obtain written informed consent from the client. Electronically recording sessions without permission. Permitting the third party to observe the activities. Releasing information concerning a client to a third person. Failing to protect confidences. Providing somebody else access to the records. Disclosure of the other person in one's work or practice setting. Billing practices and advertising involving dishonesty, fraud, conceit, or misrepresentation. Using alcohol or illegally using any controlled substance for performing the duties or services as a marriage and family therapist. Making sexual advances toward or engaging in physical intimacies or sexual activities with one's client, student, or supervisee. Making sexual advances within 24 months that the person has been a client. Undue influence promoting sales or service of goods for private gain. Permitting any person to share in the fees of professional services other than the partner or employee for a referral. So notice it didn't just cover doctors and so on. You can't pay anybody for a referral. Soliciting or assuming professional responsibility for clients of another agency. They could say you're soliciting somebody else's client, and that would be unprofessional conduct. Making claims of professional superiority that you cannot substantiate. Guaranteeing that satisfaction or a cure will result from performing or providing any professional service. Claiming or using a secret or special method of treatment or technique that one refuses to disclose to the board. Ordering tests, procedures, or treatments, or using treatment facilities or services not warranted by the client's condition, best interests, or preferences. Taking credit for work not personally performed. Making or filing a report that one knows to be false, distorted, erroneous, incomplete, or misleading. Failing to notify the client promptly when one anticipates terminating or interrupting services to the client. That's called abandonment. Abandoning employment under circumstances that seriously impair the delivery of the professional care of clients and without providing reasonable notice to the employer. Failing to terminate marriage and family therapy services when it's apparent that the relationship no longer serves the client. Supervising in a neglectful manner. When applicable, failing to inform a client that a marriage and family therapist services provide under supervision. Engaging in dual relationships with a student or client or supervisee. Not reporting when you have a reasonable belief that the client is involved in harming or has harmed a child, whether by physical, mental, emotional abuse or neglect. Not reporting somebody as a resident of a daycare facility if you feel they're being neglected. Not reporting somebody that would be considered to be mentally incompetent if they're being hurt or harmed in any particular way. Failing to file a report or a record required by the state or federal law. offering to perform or perform services, procedures, and therapy that would constitute an experiment on human subjects without first obtaining full and informed and voluntary consent, practicing marriage and family therapy in an incompetent manner, practicing marriage and family therapy when your license expires, using any license or continuing to use any license that has expired, or any title or abbreviation by the law. So that's a lot, right? But do you see how many areas are covered that you don't really think through so much that you really have there? So what do we need to do? First, check out your own state and your own profession to know what is really covered and what is really considered to be unprofessional conduct. It might seem to be overwhelming, but don't let it overwhelm you. Why? Because God is still in charge. He hasn't died as far as I know, and He is in charge. And what does He expect of you? To do the best you can. But just realize there are so many situations in so many particular ways that you could be accused of unprofessional conduct, that you can't let that get the best of you. 2 Corinthians 9:8. And God is able to make all grace abound toward you, that you, always having all sufficiency in all things, may abound to every good work. What's the bottom line? We have a calling. Our calling is to help people. Yes, there are all these laws, and these laws are normally applied in only extreme circumstances. But they're there. And so you have to realize that you are vulnerable to a certain degree, and you need to do the very best to cover all the bases and do the very best job you can, and to continue to help people in spite of these seeming like overwhelming requirements. Let's pray. Lord God, we thank you that you've given us the privilege to be able to touch other people and to help other people. And yes, Lord, it does seem very overwhelming to us, but we know that nothing overwhelms you and that you have it all under control, and that we are simply your servants trying to serve you, and we will give you all the glory and all the honor and all the praise in Jesus' name. Amen.